I'm Jonathan Forsey, Special Counsel in Duncan Cotterill's litigation team.
And I'm Peter Fernando, Senior Associate in Duncan Cotterill's commercial team.
So why do we need a new Privacy Act? Well, since the old Act was put into force in 1993, there has been an increasing sense that New Zealand is falling behind the times in protection of personal information, and there is a greater risk of data breaches because of the volume of information stored electronically and eroding public confidence in the way in which their personal information is being protected. Just looking at New Zealand examples, relatively recently, LPM Property Management in Wellington held expired and active passports from New Zealand and overseas, driver's licences, evidence of age documents and photos for over 31,000 people. The Wellington, Kapiti and Wairarapa's primary health organisation inadvertently released medical centre enrolment information including names, ages, ethnicities and addresses, and specific health information including smoking status and vaccination status for up to 1 million New Zealanders, anyone enrolled in a medical centre in that region between 2002 and 2019. Generate, a Kiwi Saver provider, released personal data held in its online application database for 26,000 people. So data breaches can be quite large, and they don't just happen overseas. It's not just big internet service providers or government agencies that are the culprits.
So the current New Zealand privacy law, the Privacy Act 1993, has been in force for over 25 years. Now this piece of law was enacted when emails and the internet were just in their infancy. The situation around storing data on computers, on online storage and on social media was completely different than it is today. These technologies were only just being developed, were only just coming into use, and it reflected an earlier time. And of course, we'd all agree, things have really moved on. Curiously, under the existing Act, 1993, there's no requirement to notify someone about a privacy breach. So, if there is an incident, a business can, at the moment, keep that quiet without the Privacy Act imposing any particular consequence. That's one thing that's going to change, and we'll talk about that shortly. And also, given when this Act was passed, there were very few provisions dealing with the offshore storage and processing of data. Now, of course, that's changing in the new Act as well. So before moving on to the new Act, it's worth quickly running through the principles from the current Act, because a lot of these are not changing. So the main guts of the 1993 Privacy Act are the 12 information privacy principles. The first one is around the purpose of collecting personal information. The principle is that an agency should only collect personal information for a lawful purpose that's connected with its functions. Principle 2 is about the source. Ideally, you would collect personal information directly from the individual concerned. Principle 3 is really important. This relates to when you go about collecting personal information from an individual. In that situation, you should let them know why you're collecting it, what purpose you'll use it for, who you will disclose it to, and a few other things that are relevant at the time of collection. Principle 4 is around not collecting personal information unfairly. Principle 5 is also really important. This is around taking reasonable protections and safeguards to ensure that personal information is not misused or inadvertently disclosed or accessed in a way that breaches the law. And Principle 6 is around an individual's right to access personal information that you hold. Now this is a right to request access, and as we'll see in the new Act, this is changing a little bit as well. Principle 7 is around correction of personal information. This is a right for an individual to request correction of the information that you hold about them. Principle 8 relates to accuracy. This is the important step of checking that the information you hold about an individual is accurate before using it. For example, not sending correspondence to an old address of someone, because obviously if they don't live there anymore, they're not going to get that piece of mail unless they have redirections. So it's important that you set that up at your end to make sure that you send it only to people who are supposed to receive it. And of course this applies not just to addresses, this is any personal information that you hold about someone. Principle 9 relates to the length of time that you can store personal information. The principle here is to not store it for longer than necessary. So there may be information that needs to be kept for particular reasons, for a particular length of time, but after those reasons have passed, that information should ideally be securely destroyed. Principle 10 relates to the limits on use of personal information. Unless an exception applies, personal information collected for one purpose can only be used for that purpose. Principle 11 is around disclosure. Information collected for one purpose can only be used for that purpose, unless an exception applies. And finally, Principle 12. Now this is one that's changing. We've included the new Principle 12 here. This relates to disclosure of personal information outside New Zealand, and we'll be talking about that a little bit more in a moment. So what are some key points? The first one is to make sure you collect information in a compliant way. Now, every agency should appoint a privacy officer who's responsible for understanding and making sure the agency complies with the Act. And when you go about collecting personal information from people, make sure that it's clear why you're doing it. Make sure those purposes are clearly outlined so people understand what you're collecting and why. It's also important to make sure you understand how your agency is holding personal information. Principle number 5 makes it clear that an agency has to take such steps as are reasonable in the circumstances to protect personal information against loss, misuse and unauthorised disclosure. So therefore, if you don't know where the data is being held or who's storing it or what protections apply, you might not be able to comply with that piece of the law.
So let's talk about the new Act. Despite the title, Privacy Act 2020, it's not really new. It's more of a modification of what we had already. It comes into force on the 1st of December 2020, and the core elements of the Act are the same as the ones that Peter has just gone through. There are now 13 information privacy principles, one new one because it's a lucky number, and some of the highlights are that there are mandatory breach reporting, which you'll have seen a bit about in the media. The Act also deals with the international effects of how data is handled, with rules around extraterritoriality and cross-border data transfers. There are also new powers for the Privacy Commissioner, the ability to issue binding decisions on complaints, and also to issue compliance notices requiring agencies to do things to comply with the Privacy Act. Turning to mandatory data breach notifications, because this is the thing that has everyone all excited. This applies to notifiable privacy breaches. So this is where the unauthorised, so we're not talking about something you've done for a lawful purpose, but where the unauthorised or accidental access to or disclosure, loss, alteration or destruction of personal information. So it's not just disclosure, it does include loss, alteration or destruction. If you lose client records, for example, that would be covered. Has caused or is likely to cause serious harm. So that is the test for whether you notify a breach. Not every breach would have to be notified, but where it has caused or is likely to cause serious harm. Now, the Act doesn't define for us what serious harm means. It's one of those things, I guess, that you will notice when you see it. The Privacy Commissioner has, however, helpfully issued some examples of serious harm, and these include physical harm or intimidation, financial fraud, including unauthorised credit card transactions or credit fraud, family violence, and psychological or emotional harm. And if any of those apply to constitute serious harm, you're obliged to notify the Privacy Commissioner and notify affected individuals. It's important to note that the focus is on what is likely to cause serious harm, not on the category of information itself. For example, for one person, the disclosure of their home address mightn't be of any particular relevance or cause for concern because they are in the electoral roll or otherwise recorded in public manner as living at that address. But for somebody who is endeavouring to protect themselves or a loved one from the results of an abusive relationship, the disclosure of that address will be extremely serious and could well have the potential to cause serious harm. So not all information is treated the same, and the focus is on the consequence, not on the information itself, although obviously bank account details and things would be more likely to facilitate the fraud and credit card issues that the Privacy Commissioner has highlighted. So what do you have to do? You have to notify the Privacy Commissioner, and you do that as soon as practicable, and you have to describe the breach, including the number of people affected, the identity of any person or body suspected of being in possession of the personal information. So if you've emailed it to one person, you'll be able to provide that email address, the incorrect one that you sent the information to. In other situations where you've been the subject of a hacking attempt or a phishing attempt, you won't necessarily know, but you've got to provide the Privacy Commissioner with as much information as you do know, and you have to do that quite quickly. It's within 24 hours of you becoming aware of the breach. You also have to advise the steps that have already been taken or that you intend to take, and if you aren't able to notify the affected people, provide the reasons why. You also need to provide the details of any other agency advised of the privacy breach, which could include legal advisors, insurers for organisations with cyber insurance, IT technicians, or the police, where the information involves potential criminal activity in hacking or attempts at blackmail, for example. And there is a fine of up to $10,000 for the agency for failure to notify. Note that it's not a fine for the breach itself, it's a fine for the failure to notify. You also then have to notify a breach to the affected individuals. You have to do this as soon as practicable, and again, if not practical, to notify each individual by public notice. And you have to describe the breach, including the number of people affected, whether the identity of the person or body suspected of being in possession of the information is known, but you mustn't disclose their identity unless that's necessary to prevent a serious threat. Steps that you've already taken or that you intend to take, and recommended steps to mitigate or avoid potential loss or harm. For example, recommending to people that they change their passwords if sensitive financial information has been disclosed. You also have to record that the Privacy Commissioner has been notified, and it's important when you do this notification to an affected individual that you don't disclose information about any other affected individuals and compound the problem. The Australian Foreign Affairs Ministry recently was an example of this, unfortunately, when it contacted Australian citizens stranded overseas with information about how they might find their way back to Australia, and they copied in all of the recipients using their personal contact addresses in the main email field. When there was a complaint received about this, they apologised profusely and sent out another email with the information sent in the CC field, which caused them to again issue a further apology. And that's not the kind of situation that you want to be in, and one day they will discover the BCC field in the email.
The new Privacy Act is clearly intended to have an extraterritorial effect. Now, what do we mean by that? That means that this Act absolutely covers situations where a New Zealand agency stores information overseas, or an overseas agency collects personal information of New Zealanders. So this is activated by an agency carrying on business in New Zealand. So clearly, as a New Zealand-based agency, you'll be carrying on business in New Zealand, and therefore the Act will definitely apply. But it also covers other overseas agencies if, for example, they are collecting information from New Zealanders. Now, the Act makes it clear that a business could be carrying on in New Zealand without necessarily seeking to make a profit in New Zealand, without necessarily being a commercial agency, and without necessarily having a physical place of business in New Zealand. So it has quite a broad reach in that respect. On a related topic, the Act now also deals with a situation where data is transferred from one agency in New Zealand to another agency, or even the same agency, offshore. In that situation, if you are transferring information of New Zealanders to an overseas entity, there are new hurdles that need to be jumped through in order to make sure that that's compliant. One example could be to make sure that the foreign person or entity is subject to New Zealand privacy laws. For example, if they were carrying on business in New Zealand, then the Privacy Act would apply, therefore they'd be subject to New Zealand law. Another way would be to make sure that they are subject to overseas law that offer comparable safeguards to the New Zealand Privacy Act. Now, we don't currently have a list of who those overseas countries are, but we understand the Privacy Commissioner will be working on that list and will be releasing it soon. Another way would be to make sure that you have appropriate contractual terms between you and the foreign person. In that situation, they'd be agreeing to protect the information to an appropriate level and would give you rights to access and would also, of course, need to tell you if there was a privacy breach. So there's a few different parts there to make an overseas transfer work. Now there's also, on a related topic, an exclusion for overseas processing and hosting. Now this applies in a situation where a foreign person is holding data that you have given them, and the only reason they're doing it is to store it or process it for your purposes. The classic example would be a cloud storage provider. Now, provided that they are only using it for the purpose of providing services to you and not using it for their own purposes, it may be that they are deemed to be acting as your agent, in which case it wouldn't necessarily be a disclosure by you to them, in which case you wouldn't have to jump through those hurdles I just mentioned. So obviously the contract terms will be really important to work out whether this exception applies or not.
Just touching now on some of the new powers of the Privacy Commissioner. The Commissioner can make access directions, basically directing an agency to provide an individual access to that individual's personal information in any manner that the Privacy Commissioner considers appropriate. This is something that the Commissioner can't do under the current Act, and also can issue what's called compliance notices for a breach of the Act, for an action that is to be treated as a breach of an information privacy principle, or an interference with the privacy of an individual under another Act, or a breach of a code of practice for the specialist codes such as health information privacy and in relation to financial services, which will still exist under the Privacy Act 2020 as subordinate but specific obligations on agencies holding information relating to those matters. There are new criminal offences with a fine of up to $10,000 for people who obstruct, hinder or resist the exercise of the Commissioner's powers, refuse or fail to comply with any lawful requirement of the Commissioner, making a statement or giving any information knowing that the statement or information is false or misleading, falsely representing that they hold authority under the Act, impersonation of an individual or falsely claiming to be acting under the authority of an individual to obtain access to personal information or have it used, altered or destroyed. So if somebody is claiming to be acting on behalf of somebody else and requests information that's provided to them, that is an offence on their part and may also cause an issue for the agency that provides the information if they didn't do any checking. It's also an offence to destroy any document containing personal information that includes an electronic record, knowing that a request has been made in respect of that information. Basically, the picture is that there's a lot more machinery that the Commissioner has to deal with complaints and to deal with them more effectively at a lower level. There is also the capacity to bring class actions on behalf of people in terms of categories of complaint which didn't exist under the previous Act. Some practical steps if you have a data breach. Contain the breach and assess what information was lost and take any immediate steps that are possible to prevent a similar occurrence. You don't want to be making the same mistake twice. Notify your insurers if you have relevant cyber coverage. Notify the Privacy Commissioner. Notify people affected by the breach with information about what happened, what has been done to limit the risks, and then take steps to prevent another breach. That could involve a security audit if it was an IT issue, reviewing policies and procedures, and also employee training, because in large part the sensitive handling of personal information and confidential material is a matter of organisational culture and training, not just having a manual which is used to prop up a wobbly desk, but actually incorporating it into part of the culture of the organisation so that people's personal information is respected, files are people too, and people have an approach which is essentially, if things are being done in relation to other people's personal information that they wouldn't like being done to their own, that is stopped and that kind of behaviour is ended in terms of the organisation's approach to information. All of this is designed to ensure compliance with the legislation, but also minimise the reputational risk, because you don't want to be appearing in the media or elsewhere as having an unreliable reputation for dealing with confidential or sensitive personal information, and you don't want to be an early target for the Privacy Commissioner exercising the Commissioner's powers to make examples of organisations that don't comply with the Act. Thank you for your time. If you'd like to get in touch with us in relation to any specific queries, our contact details are at the end of the video.
Get ready for the new Privacy Act coming into force on the 1st of December 2020.
Now remember, keep it secret,
Keep
keep
it
it safe.